Hey everyone, it's the Brown Conservative bringing you more news out of Canada. This article from the Vancouver Sun came out on May 13th, so I'm a little bit behind the ball, but better late than never. This was a really interesting and troubling article, so let's go through it. Canada's Supreme Court says extreme intoxication a valid defense in murders and sex assaults. The High Court on Friday said a law passed by Parliament in 1995 that prohibits the defense was unconstitutional. The Supreme Court of Canada on Friday ruled that defendants accused of violent crimes such as homicide and sexual assault may use self-induced extreme intoxication as a defense, striking down a federal law supported by women's advocacy groups. The Supreme Court said a law passed by Parliament in 1995 that prohibits the defense was unconstitutional and violates the country's Charter of Rights and Freedoms. We're going to get to that a little later. Its impact on the principles of fundamental justice is disproportionate to its overarching public benefits. It should therefore be declared unconstitutional and of no force or effect, said Justice Nicholas Cassirer, writing for a unanimous Supreme Court. I'm just going to stop right here. So I'm aware that the ruling that came out by the Supreme Court on this specific case that's involved in this is like 104 pages, and I have not read it, any of it. But I have to say, just I find it highly surprising that 9 Supreme Court judges unanimously agreed to strike down this law and to allow for extreme intoxication to be used as a viable defense for rape and murder. Anyways, Cassirer said the use of the Criminal Code section violated the Charter because a person's decision to become intoxicated does not mean they intended to commit a violent offense. No, it does not mean that they intended to commit a violent offense, but if you voluntarily take enough drugs or alcohol to get to that point of where you're committing offenses, I don't know, I just personally think that you should be held liable for that. Anyways, the charter was also violated because an accused could be convicted without the prosecution having to prove the person was willing or meant to commit the crime or the act. At issue was whether defendants accused of a violent crime in a criminal court may raise extreme intoxication, known as non-mental disorder automatism, as a defense. In doing so, defendants can claim their actions were involuntary as a result of taking drugs or alcohol, and as a result, they cannot be held criminally responsible for their actions. The court said it is the law in Canada that intoxication short of automatism is not a defense for the kind of violent crime at issue. Canadian courts have been divided on the matter, while women's advocacy groups have said the law is needed to protect women and children as violence disproportionately affects them. I think that a law is needed to protect everyone, women and children, definitely, because this violence does probably disproportionately affect them. Well, not probably. I think it does. It statistically bears out. But even if you assault or commit violence on another man, because you decided to voluntarily drink too much, yeah, I think you should be held liable, and that shouldn't be a defense. Your stupidity for over drinking should not be a defense to crimes you commit for being an idiot and drinking too much. Anyways, 4 of every 5 victims of intimate partner violence were women, and women were 5 times more likely to experience sexual assault in 2019, based on Canadian government data. The issue came before the Supreme Court last fall when justices heard arguments regarding the constitutionality of the statute as it pertained to 3 separate cases. In Friday's ruling, the court said a trial can be ordered in one of the cases, while restoring an acquittal in another. The third case involved Calgary man David Sullivan, who attempted suicide on December 2013 by taking a prescription drug known to cause psychosis. In a psychotic state, he stabbed his mother, whom he thought was an alien. Sullivan was convicted of aggravated assault and assault with a weapon after the judge said he could not use an extreme intoxication defense. The Court of Appeals, however, found the extreme intoxication law unconstitutional and acquitted Sullivan on both counts. Prosecutors appealed the ruling to the Supreme Court, which upheld his acquittal in Friday's ruling. Was he prescribed those medications? Because if he wasn't prescribed them and decided to take them anyways, then again, it's on him if he could have reasonably known they would have caused psychosis. And you can go to Google now pretty quickly and find out the side effects to virtually any medication out there. So I don't see how that's a valid defense still. I still don't get it. I know there's obviously more intricacies to it, but I know there's just so many glaring issues. Anyways, let's keep going with this. Kassir wrote that there are other paths for Parliament to achieve its goals to address extreme intoxicated violence. In 1994, the Supreme Court had ruled in favor of an extreme intoxication defense by a suspect who was accused of sexually assaulting a woman in a wheelchair while he was drunk. In response to the Supreme Court's ruling, Canada's Parliament passed a law which prohibited defendants from using extreme intoxication as a defense in violent crime cases. That law was enacted in 1995 and should still be held today, in my opinion. So now this is the Government of Canada website, and I'm going to read through the actual changes to the criminal code, or not the actual changes themselves, but a brief synopsis put out by the Government of Canada, the Trudeau Liberals, and we'll see what they have to say on the actual changes here. So these are changes to section 33.1 of the Criminal Code on self-induced extreme intoxication. On June 23, 2022, amendments to the Criminal Code relating to self-induced extreme intoxication received royal assent and came into force. The amendments address extreme intoxication and aim to improve the criminal justice system, support victims and survivors of crime, hold offenders to account, while respecting the Charter rights. On June 17, 2022, the Minister of Justice and Attorney General of Canada introduced Bill C-28 to amend the Criminal Code to respond to the Supreme Court of Canada's May 13, 2022 decision on the defense of extreme intoxication, which is R.V. Brown and R.V. Sullivan and Chan. The Supreme Court ruled that the section of the Criminal Code that prevented the use of the extreme intoxication defense for most crimes of violence was unconstitutional. These changes to the Criminal Code closed the gap in the law following the Supreme Court decisions by ensuring that individuals who voluntarily consume intoxicants in a criminally negligent manner become extremely intoxicated, lose control, and harm others are held criminally responsible. Negligence in this context means a person has not taken enough care to avoid a reasonably foreseeable risk of a violent loss of control. So without even going further, let's just look at obvious holes that can be poked in this. Negligence in this context means a person has not taken enough care to avoid a reasonably foreseeable risk of a violent loss of control. So let's just go down the extreme intoxication based off of alcohol alone. If this person has drank heavily on multiple occasions and has not become violent, then this looks like it would become a viable defense, because it can now be argued that that person could not reasonably foresee a risk of a violent loss of control because he's been blackout drunk multiple times and never been violent until he was. Anyways, the amendments promote public safety, particularly for those who are at risk of facing violence, such as women and children, while respecting charter rights. They also support the Government of Canada's broader commitment to increase access to justice for victims and survivors of crime and improve confidence in the criminal justice system. What are the amendments to the Criminal Code? These amendments reenact and amend Section 33.1 of the Criminal Code. The new provision ensures that individuals who harms another person while in a state of extreme intoxication will be held criminally responsible for their actions if there was a foreseeable risk that they could violently lose control over their actions when they consumed the intoxicants and they failed to take enough care to prevent that risk. Again, this I think makes it overly broad. This is just really overly broad because of that foreseeable risk that they could violently lose control. If you're a drug user or you're trying drugs for the first time and you can say, well, I know I've seen 10 of my friends take it and none of them reacted in a violent or criminal way outside of just getting high criminally, then how would that not be a viable defense? Because you couldn't foresee the risk because you've seen multiple people take it and they were fine. Right? Again, this is a little bit wild to me. I don't understand how the Supreme Court unanimously struck down these laws. What is extreme intoxication? Extreme intoxication, akin to automatism, is a state where a person is unaware of or has no voluntary control over their actions as a result of intoxication. The Supreme Court has recognized that alcohol alone will almost never lead to a state of extreme intoxication. So if they're saying alcohol alone won't do it, what else do they think they're mixing it with? Cocaine? Heroin? And if they do mix it with cocaine or heroin, then and then kill someone, it makes it better. An accused person has to prove they were in a state of extreme intoxication akin to automatism, which requires expert evidence at trial. What is the impact of the Supreme Court decisions? The Supreme Court decisions left a gap in the law that these amendments address. While such cases would be rare, the effect of the Supreme Court decisions was that individuals who negligently self-intoxicate to an extreme level, lose control over their actions, and harm others could have escaped criminal consequences. This was the case even in situations where a reasonable person should have known that they could lose control and harm others. The person made no effort to minimize that risk. And the person made no effort to minimize that risk. What was the previous criminal code provisions relating to the defense of extreme intoxication? By being drunk or high, short of extreme intoxication, being drunk or high, short of extreme intoxication, is never a defense where a person commits crimes such as assault, sex assault, and manslaughter. The previous version of Section 33.1 of the Criminal Code, struck down by the Supreme Court in May 2022, dealt with violent offenses committed while in a state of self-induced extreme intoxication. The Supreme Court found that previous Section 33.1 denied the accused the availability of using self-induced extreme intoxication as a defense for violent offenses like assault and sexual assault, even where a reasonable person would not have foreseen the risk of a violent loss of control. In other words, the Supreme Court concluded that it unfairly held people criminally responsible for actions they committed while in a state of automatism that they could not have reasonably predicted when they chose to consume intoxicants. So again, this is just so overly broad that it could be applied in so many ways off the top of my head, where you can easily say that you couldn't have reasonably predicted that something was going to happen. Anyways, what Did the Supreme Court of Canada decide in R.V. Brown and R.V. Sullivan and Chan? The Supreme Court found the previous version of Section 33.1 was unconstitutional because it violated Sections 7, the right not to be deprived of liberty except in accordance with a principle of fundamental justice, and 11D, the presumption of innocence of the charter. Um, I'm going to stop this right here because we're actually going to look at these and see if it clearly defines why the Supreme Court decided to make this ruling. So let's see, it's Section 7. So, legal rights to life, liberty, and security of persons. Section 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. I'm not sure how the Supreme Court would find this to be a violation if you consume an intoxicant to the point that you lose control. No one infringed on your right to life, liberty, or the security of your person except for you. You infringed on the right to liberty and the security of your person when you decided that you were going to overconsume intoxicants and then do something horrible once you actually were intoxicated past the point of being rational and knowing what you were doing. So I'm not sure, just reading this, how the Supreme Court actually struck it down on that clause alone, but let's take a look at the other clause, which is 11D. So 11, any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. So I'm not sure, again, why the Supreme Court actually struck this down based on 11D either, because how is it a violation of Section 7, your presumption to innocence, if you're still given your day in court with a jury? Obviously, the ruling will probably explain this a little bit better, but I don't particularly feel the need to go read it, because just based on this alone, I think it's wild, and I think our Supreme Court judges should be ashamed of themselves. Actually, I don't know how they made such a large leap. Anyways, we will go back here and see what else it says. The Supreme Court found that previous Section 33.1 denied the accused the availability of using self-induced intoxication as a defense for violent offenses like assault and sexual assault. The wording here is so interesting. Section 33.1 denied the accused the availability of using self-induced intoxication as a defense for violent offenses like assault and sexual assault, even where a reasonable person would not have foreseen the risk of a violent loss of control. It is wild, just absolutely wild, that the Supreme Court would ever allow this. I kind of keep saying the same thing over and over again. It's just so mind-boggling and wild. Bill C-28 amended the Criminal Code to replace the old provision with a newer version of Section 33.1 that will protect victims, hold offenders accountable, and respects the Charter. Did the Supreme Court of Canada decide that someone could use drunkenness or being high alone as a defense to assault someone? They say no, but I fail to see how that's accurate. The Supreme Court was clear that drunkenness is not a defense for committing criminal acts, including assault and sexual assault. The Supreme Court's decisions do not apply to the vast majority of cases involving a person who commits a criminal offense while intoxicated. The Supreme Court ruling applies only in the rare instance where a person chooses to ingest substances that cause intoxication so extreme as to result in a state of automatism and then harms another person. The Supreme Court also made clear that alcohol alone will almost never result in a state of extreme intoxication akin to automatism. How can they say that? I know many people, as I'm sure many of you watching this do, who have had a lot of alcohol and become blackout drunk. You can have a conversation with them, and the next day they have absolutely no clue what they talked about. They didn't even know they talked to you at all. Um, I've seen many people be blackout drunk, and let me just say I've haven't seen any of them get up and go rape people. Again, I think you have to be a special type of sick to do something like this, even while intoxicated. Thanks for listening, everyone, and I guess I'll see you in the next video. Oh yeah, guys, this is a list of all our Supreme Court uh, justices who unanimously voted to allow broader, more viable defenses to be brought to the courts by rapists, murderers, and violent offenders.